Morning, everyone. My name is Ryan Goodwin, and I am the president of the New Jersey Lawyers Chapter. I'm delighted to introduce our first panel today, who will discuss a particularly topical issue concerning the scope of presidential power under Article 2 of our Constitution. And I can think of no better location for this discussion. To address the shortcomings of the Articles of Confederation, the framers debated our country's need for a vigorous and unified executive just steps away from where we sit today. Our moderator this morning is the Honorable Thomas M. Hardiman. Judge Hardiman has served on the United States Court of Appeals for the past 18 years since his Senate confirmation in 2007. Most recently, Judge Hardiman also served as a board member of the Federal Judiciary Center from 2020 to 2024. Prior to becoming an appellate judge, Judge Hardiman served as a judge on the United States District Court for the Western District of Pennsylvania. And in private practice, Judge Hardiman handled a wide variety of state and federal litigation matters as a partner with the firms of Reed Smith and Titus McCumbee. He is a graduate of the University of Notre Dame and received his law degree from the Georgetown University Law Center. Our panel today features Louis Capozzi, Stephen Engel, and John Gore. Louis Capozzi is an attorney at Jones Day, where he specializes in appellate advocacy and motion practice. Prior to private practice, Lou clerked for Justice Neil Gorsuch on the United States Supreme Court and Judges Harvey Wilkinson of the United States Court of Appeals for the Fourth Circuit and Anthony Sirica of the United States Court of Appeals for the Third Circuit. He graduated valedictorian from the University of Pennsylvania Carey Law School, where he also serves as a lecturer in law. Stephen Engel is the chair of the Appellate and Regulatory Litigation Group at Dykert, where he handles a wide range of civil litigation matters and counsels clients on challenges to agency regulations and on congressional and internal investigations. Stephen previously served as Assistant Attorney General for the Department of Justice's Office of Legal Counsel, where he was awarded the Edmund J. Randolph Award for outstanding service to the department. He has taught at both the Antonin Scalia School of Law at George Mason University and the Columbus School of Law at the Catholic University of America. Stephen clerked on the United States Supreme Court for Justice Anthony Kennedy and on the U.S. Court of Appeals for the Ninth Circuit for Judge Alex Kaczynski. He is a graduate of Harvard, Cambridge, and Yale Law School. John Gore is a partner at Jones Day with extensive litigation experience, including arguing before the United States Supreme Court, and has first chaired trials and appeals across the country. John previously served as acting Assistant Attorney General for the Civil Rights Division at the Department of Justice, where he led the department's civil and criminal civil rights enforcement nationwide. There, John launched several successful law enforcement initiatives, including an initiative to combat housing discrimination, an initiative to end employment discrimination, to protect religious liberty, and to uphold First Amendment freedoms. He clerked for Judge Bruce Celia on the United States Court of Appeals for the Fourth Circuit. John is a graduate of the University of Colorado and the University of Texas Law School. I would like now to turn the program over to Judge Hardiman, but before I do, please join me in welcoming our distinguished panel.
A pleasure to be here with everyone this morning, and particularly a pleasure to be here with these three extraordinary lawyers. We're going to proceed in the normal way. We're going to have opening statements from each. Steve is going to go first, followed by John, and then Lou, and then I'm going to give the panelists an opportunity to comment on anything that they might have heard from their colleagues, and I may ask a few questions as well, and obviously we'll leave some time for your questions, not speeches, but your questions. And since we launched a little bit late, I've been advised that we can go till 12:15. So if we get to 12 o'clock and we're not in the question phase yet, and you really want to ask a question, don't worry, we're going to go till 12:15. So without further ado, let me turn it over to Steve.
Well, thank you, Judge. Great to be here this morning. It's a beautiful day out, and it's a great location for an event. I think, as Ryan indicated, this is a timely subject since debates about executive power these days have moved from the case books to the newspapers, at least for those of us who still read newspapers. But there have been at least 210 separate lawsuits lodged against the Trump administration in under 100 days. And it is rare that a day goes by without the grant of an injunction, the denial of an injunction, the affirmance of an injunction, or the vacatur of an injunction, as the case may be. And on most days, we're seeing 2 or 3 such decisions. Now, in most of these cases, the challenge action concerns, at least in part, an assertion by President Trump of his authority under Article 2 of the Constitution, which vests all executive power in the president. And so the future of executive power is quite literally being written as we speak, and as we will see over the next few years. And I'm sure we'll have a lot to say this morning about the Trump administration, but I wanted to start by setting the scene on where we're coming from, because though it seems like a long time ago, President Biden recently finished a 4-year term, and while he may not have trumpeted his muscle as vocally as the current president does, President Biden advanced a very aggressive view of executive power, relying heavily upon unilateral presidential authority to set policy on the issues of the day. And so he came out of the gate by seeking to wield the executive's emergency authorities to address the COVID pandemic. And so that led his administration to impose, without congressional authorization, nationwide vaccine mandates, mask mandates, and the like. But his efforts went well beyond COVID, pushing what I think it's fair to say is possibly an unprecedentedly broad view of the regulatory authority of the administrative state and ultimately the president. The administration forgave or sought to forgive $400 billion of student loans, again with the sweep of a pen, and sought to employ executive power to advance a long list of progressive policy goals, be it greenhouse gas regulations of automobiles and power plants, DEI initiatives, net neutrality, cryptocurrencies, non-compete clauses nationwide, and the list goes on. And in those areas, the Biden administration leaned heavily upon the Chevron doctrine, which called for the federal courts to defer to an agency's own interpretation of ambiguous federal statutes. And despite the Biden administration, or maybe because the Biden administration was so aggressive, its ultimate record in this area on executive power was not so good. When Biden administration regulations were challenged in federal court, and most of the time they were by industry groups, by state attorneys general and the like, the administration wound up losing in the big cases more often than not. And the Supreme Court not only cut back on particular assertions of regulatory power, but it did so through landmark decisions that have really sharply narrowed the power of the administrative state. And most notably, the court adopted the major questions doctrine in cases like West Virginia versus EPA and Biden versus Nebraska, holding that administrative agencies could not rely upon vague and open-ended statutes to discover regulatory powers to address issues of vast economic and political significance. Biden administration's efforts also proved the death knell for Chevron. After knocking down multiple regulations as contrary to text, the court in Loper Bright overruled Chevron and held that going forward, courts will interpret and measure agency regulations against the best reading of the statute rather than relying upon purported ambiguities that opened up hitherto unchecked agency power. And although the court rebuffed the Biden administration's efforts at policymaking by regulation, it did strengthen the hands of the president and of future presidents when it comes to control over the executive branch itself. So in a series of decisions, like Seal of Law, Collins, and the like, the court confirmed that the Constitution vests all executive power in one president, and that the rest of the executive branch therefore must be accountable to him. In so doing, the court chipped away at earlier decisions, notably Humphrey's executor, that had permitted Congress to fragment executive power across the administration and independent agencies, and thereby weakened the policymaking or the hand of the president. The Biden administration did not always trumpet or push for a unitary executive, but President Biden did flex that power when he thought it was convenient. So early on, he broke with past practice by removing the NLRB's general counsel and the Social Security administrator, two officers that had traditionally served out their term despite a change in the presidency. And President Biden removed Trump appointees from presidential commissions and at least one career SES official because of policy disagreements. So President Trump now returns to office at a time in which the Supreme Court has endorsed the unitary nature of the executive branch, even while expressing some degree of skepticism over the president's ability to make sweeping policy decisions through regulation and emergency orders. And in the opening month, President Trump has pushed even harder on the unity of the executive branch, terminating inspectors general, removing a series of Biden appointees at independent agencies like the FTC, the NLRB, and the EEOC. And also, the Trump administration has pursued ambitious efforts to restore presidential control over the civil service, pushing back upon an entrenched bureaucracy that in some cases itself had become a power center and a check on the president. Now, President Trump's embrace of the DOGE effort, which has been, heavily covered in the news, involves particularly interesting assertions of executive power. Now, the Constitution gives Congress the authority to design the executive branch by creating offices and by setting annual appropriations for departments and agencies. The DOGE effort has sought to improve efficiency and to cut spending on both programs and personnel, often through the appointment of DOGE-aligned employees directly to the individual departments. And although the administration has sometimes invoked Article 2 in support of these efforts, DOGE generally has not challenged congressional authority over the departments and personnel, but rather has been creative in seeking to exercise the executive's statutory discretion to control these subjects. And so they've demanded that employees return to office, a novel concept. They've targeted probationary employees, and they've also taken a broad view of cause in some instances of reassignments and terminations. When it comes to spending, they've also targeted grant programs, typically based on a claim in accordance with their terms. And they've also argued that challengers must pursue litigation in administrative tribunals, not through a kind of federal court APA action that could have sweeping, authority with, a TRO 2 weeks after and the like, but pursue on a case-by-case basis. People who are wronged should go to the Court of Claims or should pursue the merit system protection procedures that are available. Now, most, if not all, these efforts have been met by litigation, often brought in the preferred courts by the individual plaintiffs. And so as the TROs and the injunctions roll out, we'll likely see in the coming month how appellate courts and ultimately the Supreme Court grant these assertions of executive power, and whether or how the president winds up in a stronger position or not at the end of the next 3.5, nearly 4 years. So as noted, these are very timely issues, and I look forward to discussing them this morning. Oh, thank you.
John?
Thank you, everybody, and thank you for being here today at this exciting conference. And Steve, thank you for your remarks. I think Steve's remarks hit on something very important. There are two broad categories of executive power that we're seeing asserted in a very aggressive way, I think, over the last two administrations. One is the president's authority and the executive branch's authority more broadly to regulate the public and to regulate private conduct. And the other is the president's assertion of authority to get control over the executive branch. And that's where we've seen a little bit of a difference in the Supreme Court's approach. But this latter category, I think, is very important for things like DOGE and controlling the civil service and appointments more generally. Because as the saying goes, personnel is policy. And two principles, I think, are obvious to our modern understanding of the presidency. The president cannot faithfully execute the laws of this country all by himself. He needs help from other officials to carry out that work. And second, he can only faithfully execute the laws if he has control over who those people are and how they discharge their official duties. The Supreme Court has repeatedly recognized and emphasized that the president's executive authority entails not only the authority to appoint executive branch officers, but also to remove them. And this is a power that presidents have used throughout the decades, and it's become an important mechanism of democratic accountability for the president. The president can't remove these people. The president can't implement the policy agenda that the American people elected him to implement. And so presidents from all parties remove officials and appoint officials based on their own policy preferences. Now, it'll come as no surprise to the people in this room that President Trump has not been bashful about exercising these powers of appointment and removal. And in fact, I think his first 100 days of his second term reflect some lessons learned from his first term. So this time around, the president and the White House have been very aggressive and very quick about nominating people to Senate-confirmed positions. And the Senate has been very rapid in terms of its confirmation of those appointees. And it's not just officials at the cabinet level. It's at the sub-cabinet level as well, where a lot of the day-to-day operations and policy decisions and executive functions are actually carried out. Many officials at the sub-cabinet level wield substantial authority over what happens at various agencies and departments, and those slots are being filled very quickly and much more quickly than they were in President Trump's first term. Another area where President Trump, I think, has been assertive about his ability to control the executive branch is where Senate confirmation or Senate nominations are pending, but the official hasn't been confirmed yet. The president has taken action to install acting heads of agencies and acting officers all across the executive branch. I think the best example is the IRS. As of last week, we're now on our 5th head of the IRS so far in 2025, and it's only April. So who knows where that tally is going to end up. But President Trump has gone out and done that at the IRS and at other places. And finally, as Steve kind of indicated, President Trump has taken action to remove from office heads of so-called independent agencies. And I refer to them as so-called independent agencies because I'm not sure there is such a thing as an independent agency under the unitary executive theory. But assume that there is. And what we mean by that is Congress, from time to time, has enacted statutes to try to preserve the independence of agencies or organizations or departments within the government by limiting the president's removal power. And so by statute, Congress will enact statutes that say that a certain official can only be removed for cause or malfeasance or neglect of duty or something along those lines. And as you can imagine, this has been very controversial throughout the decades. Supreme Court's most recent decision on this is the decision in Selah Law that Stephen alluded to earlier. And that was a 2020 case in which the Supreme Court went to great lengths to emphasize the breadth of the president's removal power and that it's a virtually unchecked power. Supreme Court has recognized 2 exceptions to that power when it comes to one that applies to independent agencies and one that applies to inferior officers. The first is the Humphreys Executor line of cases where the Supreme Court in Selah Law kind of characterized those as involving multi-member agencies that did not wield substantial executive power. So the test there is it a multi-member agency and does it wield substantial executive power? The second exception is for so-called inferior officers who have limited duties and whose performance of those duties doesn't erode the president's executive authority, at least in the judgment of the Supreme Court. Beyond that, the Supreme Court has basically declared open season on the removal of independent officers, so-called independent officers, notwithstanding congressional action to try to insulate those officers from removal. And so, as Steve indicated, President Trump has removed many officers who would have been considered independent and who Congress tried to insulate from removal through these various statutes. 2 of those officers have sued now the administration. One was Gwen Wilcox, who was a member of the National Labor Relations Board, and the other was Kathy Harris, who was at the Merit Systems Protection Board. They filed suit in the United States District Court for the District of Columbia. That court held that President Trump's removal of them was illegal under the statutes. It declined to issue a stay. The Trump administration appealed that to the D.C. Circuit. The panel granted a stay. The en banc court then vacated that stay. And as part of the remedy that was ordered was an order to reinstate these officials. So the president had removed them, and the courts had said that they had to be reinstated to their positions at the NLRB and the MSPB, respectively. The Trump administration is now taking that to the U.S. Supreme Court, which has stayed the reinstatement order and stayed the remedy that was entered below in a stay order issued by Chief Justice Roberts. And that case will now be fully litigated to the court. It remains to be seen how it plays out. The whole question is going to turn on whether either of those agencies or boards can be kind of shoehorned within the Selah Law exceptions to the president's removal power. And of course, that's an important question, not only for that case, but for other cases as well. For example, this could play out again in the future and during this 4 years of this administration, as President Trump may take further action to remove independent officers. For example, I think it would be a very interesting question if the president changes his mind and does decide to take action to remove Chairman Powell from the Federal Reserve. And so this is an area where it's not only a question of existing law and existing decisions, but where is this going in the future, and how will it affect president's abilities to control the executive branch and policymaking that is done in these various agencies and departments.
Thank you, John. Last but not least, Lou.
Well, thank you, Judge Hardiman. It's great to be here with you today. It's great to be here with Steve and John, two of the great leading litigators in the conservative legal movement. And it's great to be here with all of you, people who care about the Constitution and the separation of powers. And in that spirit, I encourage you to ask yourself two questions. First, who in our government makes most of the major policy questions we care about today? And second, under our Constitution, what is the answer supposed to be to that question? My scholarship focuses on legislative power and how Congress lost its legislative power. And in a panel about executive power, I think it is worth thinking about at least a little bit that nearly forgotten branch of government, Congress. We do spend some money and some taxpayer dollars to elect these folks, and it's not entirely clear to me why we do so at this point. They don't seem to do very much. So I want to talk about that a bit today, and in particular, the major questions doctrine and how it may function as a check on the executive branch's ability to resolve the major policy questions of the day. So the first point, I'll answer my own first question. I do believe the executive branch has the power to resolve most of the major policy questions of the day. Steve recounted how the Biden administration aggressively used that power. I think if we're being honest, that trend is continuing in the Trump administration, and frankly, it's nothing new. That trend was true going back several administrations. I remember when the Republicans won the midterms in 2010, and you know what? Almost nothing changed because President Obama said, I can just unilaterally do whatever I want with a pen and phone. The midterm elections don't really matter. So how did we get to that point? That's a complicated historical question. The mechanics of this is Congress passed a series of statutes. I call them blank check statutes. There are about 200 to 250 of these statutes. They effectively give the president broad or even unlimited discretion to do whatever he wants with respect to a particular subject area. For labor and employment lawyers, for example, you might be familiar with the OSH Act, which gives OSHA the power to set workplace safety rules that it deems appropriate. That's the word, appropriate. That is the instruction from Congress. And you might wonder, well, if the president and through the agency gets to decide what is appropriate, who's really making the law of workplace safety? I would suggest it's the president. Statutes like that exist all over the US Code, and as a result, the president plausibly has statutory authority to make almost any policy decision that he wishes. The same is true in the tariff context, and I'm going to talk a little bit about the tariff, about President Trump's tariffs today. But first, just one more piece of introduction, the major questions doctrine. So Steve mentioned the major questions doctrine. This is an important part of administrative law in recent years, and it is a major check, perhaps the major check, on the power of the executive branch to resolve major new policy issues. The doctrine has two steps. First, the court asks, is the agency claiming a power of vast economic and political significance? If the agency is doing that, the court asks whether Congress has given clear, or you might say specific, congressional authorization for the agency to solve that problem. And as Steve mentioned, The Biden administration was very aggressive in trying to solve new problems using vague language in these blank check statutes. The Biden administration claimed the power to cancel almost $500 billion in student loans, to require universal COVID vaccination, to prohibit evictions across the country, to ban non-compete agreements, claims the power to shut down all coal and natural gas powered plants to solve climate change, and we can name some other examples too. The major questions doctrine limited and prevented the Biden administration from doing all of those things. And so it really has become the leading, I would say, check on the legislative powers of the executive branch. I will just flag for those who are interested in this topic, I've written some articles defending the major questions doctrine. I just, in the Notre Dame Law Review, published a full theoretical defense of the doctrine. As a formalist matter, I believe the doctrine is necessary and appropriate to enforce Article 1 of the Constitution, which does guarantee that Congress make law and that it does so through a very reticulated procedure. And as a functionalist matter, I've defended the doctrine because I do think that the balance of power within the federal government is frankly out of whack. The executive branch has accumulated too much power. Congress has lost too much of its power, and this is a Republican form of government. I think that we should want a healthy balance of power. When I was writing and speaking on the major questions doctrine during the Biden administration, I got lots of negative feedback from my more left of center friends. They did not like the doctrine. Now, of course, President Biden is not the president anymore. It's President Trump. And a lot of people are asking, well, how might the major questions doctrine apply to the Trump administration? Traditionally, Republican presidents, I would say, were less likely than Democratic presidents to try to do really innovative regulatory moves using old statutes. But President Trump, at least to a point, is perhaps breaking that trend. And an early example where we are seeing an attempt to wield the major questions doctrine against the Trump administration is with respect to the Trump tariffs. So this is IEEPA, the International Emergency Economic Powers Act. IEEPA was passed in the 1970s. It's interesting, actually. This was an attempt by Congress to narrow the scope of the president's emergency powers. President Trump declared an emergency, which is the inflow of fentanyl. And as a response to the inflow of fentanyl, he imposed tariffs first on Mexico and Canada, then on China, then on the entire world, then even more on China, then he pulled back on the entire world, and we're all buckled in waiting to see how the global economy will shift based on the president's actions next. So let's think about how the major questions doctrine, which has been raised in several lawsuits challenging these tariffs, let's think about how that might apply. So first, is this a major question? I would say it probably is. In the student loans case, the Supreme Court reaffirmed that if an executive action has $50 billion in economic impact, it's a major question. The United States' trade just with China, Canada, and Mexico, so that's not the entire world, just China, Mexico, and Canada, was $1.3 trillion in 2024. Considering the tariff rates on that trade, we are well over the $50 billion threshold. I think this is a major question on any account. The second question is, did Congress clearly authorize the executive branch to set tariffs under this statute? I think it's a hard question, to be frank, and I just want to briefly lay out some of the arguments. The language, frankly, in the statute is pretty broad. The president is empowered to investigate, regulate, or prohibit any transactions in foreign exchange. He's also given the power to regulate importation or exportation of any property in which any foreign country or a national thereof has any interest by any person with respect to any property subject to the jurisdiction of the United States. When you see the word any in a statute, that usually connotes broad authority. There are a lot of any's in there. I think the executive branch has a pretty plausible argument that this is that this might be clear statutory authority. On the other hand, it is true, as the challengers in these litigations have pointed out, that the executive branch has never used this statute to impose tariffs before. There are other statutes which allow the executive branch to impose tariffs, including the one the Trump administration used in the first administration to tariff steel. The reason why the administration didn't use that statute this time is that there are a bunch of procedures designed to cabin executive authority, and it takes some time. So I suspect that's why they didn't use the statute that was clearly designed for tariffs. So another point, in Alabama Association of Realtors, the Supreme Court said may be more likely to be a major question if it's a traditional area of state law. I think it's fair to say tariffs are not a traditional area of state law. This is an area of federal authority. On the other hand, the Constitution does expressly give Congress the power to levy tariffs. So I don't think we can say either that this is an inherent executive authority. This is unambiguously a legislative power under the Constitution. And so I think there are some arguments in both directions. I think if the challengers win, the court will say that Congress was intending to give the president authority to do embargoes or sanctions. You could read the language a bit more narrowly to refer only to embargoes and sanctions. There is some support in the legislative history for that reading, but it's not a slam dunk. And I would say this is not the strongest vehicle for a major questions argument because of the clarity of the legislative language. And I'll close with one final thought for you all. How did we get here? And you might think to yourself, well, it's Congress's fault. Congress passed all these blank check statutes. They wrote all those any's. They wrote all this broad language. It's their fault. They gave up their power, and so be it. The story is a bit more complicated than that. In IEPA and in almost all of the blank check statutes I referred to, Congress initially included in those statutes one-house legislative vetoes, which meant that a single house of Congress could block any action taken by the executive branch under those statutes in an up or down vote. In 1983, the U.S. Supreme Court held that all of those one-house vetoes were unconstitutional in a case called INS v. Chadha. In my view, I don't think that this is talked about often enough. I think the one-house vetoes were a fundamental part of the bargain that Congress struck in making modern American government. The Supreme Court voided that bargain in INS v. Chadha over a dissent from Justice Rehnquist, who asked, why would we sever here? Shouldn't we get rid of the blank check if we're going to get rid of the one rein that Congress had to keep control of the delegation? Because without one-house vetoes, look at where we're at now. The only way for Congress to reclaim its power is to pass a law, and the president can veto it, which he does all the time. If you look how the vetoes have been used the last 40 years, it's been used almost exclusively to protect the issuance of regulations by the executive branch. And so without the one-house veto, these blank check statutes really, there's no way to claw them back. And so with tariffs, as in so many other areas, we have a blank check where the president basically can do whatever he wants, including dramatically reshaping the global economy. He could do so unilaterally without Congress's meaningful involvement, and there's no realistic way for Congress to reclaim that power. I think that this is an important dynamic. I think it's fundamental to our modern government, and I think that we should have a conversation about whether that's a good dynamic going forward. Thank you.
Well, those were terrifically insightful comments and timely, too. Everybody did very well on time, so you made my job easy. Let's see what you had to say about each other's thoughts. Does someone want to jump in about what they heard from a co-panelist? Or?
I mean, maybe we want to start with one and then go to the other, if that makes sense.
Sure.
Or talk through.
Yeah.
I think starting with John's, I think when it comes to the unity of the executive branch, I think we're moving there. I think Law students may need to study the scope of the exception to Article 2 for Humphrey's executor in Morrison versus Olson, but I think future law students probably won't have to do so. I think the court has so far kind of gone no further than necessary in cases like Sela Law and Collins and the like, but I think the music is clear that there is a court where at least 5, probably 6 justices believe in the unity of the executive branch as to at least officers of the United States, both principal officers and also inferior officers. And I think in the cases to come, it looks like Wilcox may well be the leading case. It's now, although the remedy is stayed, it's in front of a merits panel of the D.C. Circuit, which will address it, and then in due course it may wind up at the Supreme Court. I would predict that the court will say that principal officers, at least, that the multi-member exception for Humphrey's executor, which was premised upon this notion, which has since been discarded, that that the FTC was an expert agency that was quasi-legislative, quasi-judicial, and somehow not part of the executive branch, will be discarded, and that's the future of that. I think when push comes to shove, I think the most famous opinion in Morrison versus Olson is Justice Scalia's dissent at this point, and while it was a lone dissent at the time, I think there likely is a majority, put aside the issues of independent prosecutors and the prosecutorial function in particular, but there is a court that believes that as to inferior officers, they too, because they are exercising substantial executive authority, must be within the ambit of the at least indirect control of the President of the United States. And so I think in an appropriate case, Morrison too on that is likely to be overruled. I think some of the harder questions on this front, I think, that we're likely to see, I'll say there's a very narrow but important question and then a broader question. The narrow but important question is the Federal Reserve. What about the Federal Reserve, right? The two things that the president has done in recent weeks to move markets are the tariffs, of course, but also just even talking about the potential for removing the chair of the Federal Reserve, which is seen as undermining the independence of the Federal Reserve in its open market operations, although in point of fact, the FOMC, which makes these decisions, is not just about one person, but actually has 14 members on it. And so taking control of the Federal Reserve or the FOMC is not as easy as maybe it sounds, but that moved a lot of markets that and the like. And so at least 3 justices have sort of suggested that maybe there's something different about regulating the monetary supply, and as have some other lower court judges. And so the question is there something about the status of the Federal Reserve that could create yet another exception? If we do away with Humphrey's executor, maybe there's a money supply exception, and there's historical precedents for those who focus on an originalist point of view of money supply being regulated in Philadelphia, by the first Bank of the United States and the second Bank of the United States, which were these public and private corporations. I mean, McCulloch versus Maryland was all about, could Congress charter a corporation at the end of the day? Did they have that implied power? And that was because the bank was not something like the Department of the Treasury or a separate agency. And so there are interesting questions about that, and the Federal Reserve now is a interestingly structured agency, which also doesn't just do money supply, doesn't regulate the money supply, but also involves in more traditional regulation. So that's one question which is important but somewhat narrow. Then the other question is the civil service. Is whether it's the deep state or otherwise, to what degree can the president or must the president be able to reach down into the sort of actions of functionaries who are not officers of the United States and have control over those folks? Those folks are sort of supposed to be immediately responsive to people who are exercising the substantial executive authority. And so there are sort of interesting questions. Does the Article 2 principle, does the vesting of executive power carry down to everyone with a government ID badge? Or is there some zone of people who basically are just, as I use the word functionary because it's derived from some of the cases, that can be outside of the president's direct control, and therefore can have for cause protection and the very complicated civil service protections under the Merit Systems Protections Board. So I see some of those, we still have a few years to go. Humphrey's executor and Morrison versus Olson remain precedents of the Supreme Court. But I think some of the more interesting questions will be once those are gone, as at least I would predict that they will be, what comes next?
If we're responding to John's
Yeah,
remarks, I'll jump in on this. I agree with almost everything that Steve and John said. I think that it's a very healthy thing for the president to be taking more direction and more control over the executive branch. And, people vote for the president. The people that execute the policies should be faithful and be supportive of the president's policies. As John said, personnel is policy. With respect to principal officers and Humphrey's executor, I agree that Humphrey's executor will probably be confined to its facts, maybe with a very creative way to protect the members of the Federal Reserve, where I think there is an instinct that it would be bad, perhaps very bad, for the president to just be able to directly control interest rates in response to political pressures. I suspect they will find a way to protect the Federal Reserve and basically nothing else. I think that there are some fascinating questions about the career bureaucracy as well. Judge Ho, in a separate opinion on the Fifth Circuit, flagged the status of the senior executive service. I think that that is a potential fertile area for lawsuits. By statutory definition, the senior executive service are career bureaucrats with tenure protections who exercise, I believe the statutory phrase is significant policy authority, or something close to that. That sounds to me like the sort of thing where the president should be able to control and hence remove members of the senior executive service. And I mean, let's be honest, we're not in Washington, D.C., so I'm going to throw a little anti-Washington, D.C. red meat in here. The people that are protected by the current rules, including the senior executive service, it's basically a bunch of people that live in Northern Virginia and Southern Maryland, and they're a perma-bureaucracy. And let me tell you, their values and world perspective are very different than yours. And they're very different than President Trump's, and they're going to be very different than any Republican administration. And I find it hard to believe that, as we say, personnel is policy. I find it hard to believe that these people, many of whom are my good liberal friends, are going to faithfully execute a Republican presidency's policies. And so, frankly, what the current status quo is with the civil career bureaucracy is it is a unilateral advantage for one party and a unilateral disadvantage to the Republican Party. And there's really no, at least in my eyes, justified constitutional basis for what I see as also a fundamentally unfair status quo.
John?
Yeah, thank you. A couple of thoughts on Steve's very thorough presentation. And I'll pick up kind of where Lou left off, talking about the SES and the career bureaucracy. That's what I was getting at before, which is the president's authority to control the executive branch as part of our unitary executive structure. I think not only does the career bureaucracy, particularly the SES level, favor one party over another, it favors the government's interests or a certain view of the government's interests over the public interest or over a competing view of the government's interest. And so President Trump has been a proponent of the unitary executive theory because of his views about the deep state or what goes on at in the bureaucracy at the bureaucratic level. And his ability to control what officials do, including at the SES and career level, I think is a very important part of that equation. And we've seen a different approach in the second term, a much more aggressive and robust approach to bring that aspect of the federal government and the executive branch into line with the president's priorities than we saw even in the first term. And relatedly, when I think of DOGE, I think there are a couple of interesting constraints to think about with DOGE. One is just kind of a political constraint, and one may be a legal constraint. The first is the political constraint of how far are the American people going to let the president go and let Elon Musk go and this DOGE effort go before they either lose the attention span or no longer become interested in it or just start pushing back on that particular effort. And that's an important check, I think, on executive authority more broadly. It's also interesting to think about this DOGE effort as it relates to the Supreme Court's holding in the Clinton case back in the 90s that the president does not have a line item veto authority. And that was authority that Congress had given the president by statute. The president would go through the budget and check things off and line item veto particular spending items. It's a power that governors in various states have had over time. Can the president now effectively accomplish the same thing or something similar by deciding not to spend money in a particular way or not spend money that Congress has allocated for particular functions? Can the president also have a quasi kind of line item veto authority with respect to how executive branches and agencies are organized and how that bureaucracy is structured? And so it's another important, I think, question between the president and Congress, and to what extent will the lack of line item veto authority, which is, when I went to law school, it kind of played up as a big deal in constitutional structure, going to go the way of, Steve, I think rightfully predicts, Humphrey's executor and Morrison versus Olson are headed, and that Chevron's already gone, to speak of another doctrine that was really in vogue when I was in law school. So I think those questions may get litigated. There may be litigation about how DOGE and some of these efforts to cancel spending or limit spending or rein in spending relate to this notion of a lack of a line item veto and Congress's power of the purse. But all of that remains to be fleshed out, and I think some of that will be informed by how far this effort's able to go in the current political environment.
Lou, you said you think Humphrey's executor will be limited to its facts. Do John and Steve agree with that, or do you think it may be explicitly overruled?
I think overruled. But they could also they could distinguish the FTC as it existed in 1936 as having such trivial kind of authorities. The FTC couldn't go to court. There were some ways in which it looked more like a recommendation, an advisory body or the like. They could say that that was a key fact. Although this is a court that hasn't been afraid to overrule cases. See Roe and Casey, and see Chevron sort of when necessary. I mean, there was right. And one of the facts that we're going through here when it comes to structural separation of powers is that for about, you could debate it, but probably for about 25 years, if not 35 years, the court was on a knife's edge in its alignment of justices leaning to the left and leaning to the right, with pragmatic justices in the center, and the sort of identity of this person changed over the course of time, in which sometimes there were some wins on one way, some wins on another side. At the very end of President Trump's first term, the court wound up with what appears to be a durable conservative majority, and that being the case, we're starting to see the kinds of decisions that Justice Scalia, Justice Thomas, Justice Alito, and others have sort of been arguing for, either in the winning or losing, become the law, particularly with the separation of powers and the structural separation of powers. And so that's why we're seeing, that's part of the reason why we're seeing some of this movement here. It's a different court than has existed. And to that end, it's a court that hasn't been afraid to cast aside precedents that were mistaken on the days that they were written when it's appropriate.
All right, John, you break the tie. Overruled, limited?
Well, I may punt on the tie, actually, because I think I agree with Steve and obviously with Lou that there's a current majority on the Supreme Court that doesn't believe in Humphrey's executor, or at least recognizes that Humphrey's executor was based on a fiction. And if you look at seal of law and the footnote that the chief puts in seal of law to say, look, that's what we said. We said it was quasi-legislative. We said it was quasi-judicial. Not sure that was true, but that's kind of what we went with. So I think what that raises is just kind of a litigation strategy or decision strategy for the Supreme Court is, do they actually have to overrule it? Because it's pretty easy to distinguish the FTC as it was portrayed in Humphrey's executor from any modern executive department or agency that we have now. Because, of course, the fiction in Humphrey's executor was that the FTC at the time didn't exercise any executive authority. It was quasi-legislative and quasi-judicial. Well, if you look at what the Supreme Court has now said qualifies as an exercise of substantial executive authority, it covers the waterfront. It's everything from issuing subpoenas or doing adjudications or having some kind of regulatory authority. And so I'm not aware of any multi-member agency or non-multi-member agency that wouldn't satisfy that particular test. So if they're serious about that exception, they may never need as a formal matter to overrule Humphrey's executor. It could just be a one-off case that exists as a historical anomaly within the framework of how they're going to decide these removal cases going forward.
So it raises an interesting issue because I think for us inferior judges and for practitioners, it's always interesting to see how the court phrases these things. It will come out and say, Roe is overruled. That's what it said in Dobbs. And then other times it will do things like Kennedy against Bremerton, where it said that Lemon wasn't good law anymore, but it doesn't explicitly overrule it. And then you've got what was particularly strange to me, where the chief just declared in a case where the question wasn't presented that Korematsu was overruled. So what do you all think about that as keen observers of the court? Does it matter that there doesn't seem to be a particular consistency or rigor in the way that the court wrestles with prior precedents that it's no longer comfortable with?
I'm willing to take a stab at that. So in Kennedy, for the record, Lemon was abandoned long ago. We're not going to tell you precisely when, but it was abandoned. I think the reason that the court does this, I do think this is largely a function of Chief Justice John Roberts and his particular judicial philosophy. The Supreme Court, at least as a formal matter, and there's some disagreement on how you characterize particular cases, this court, under Chief Justice Roberts, has overruled precedent at a slower rate than any court since the 1800s. And if you compare it to the Warren Court, it is not even close. I mean, the Warren Court was overruling precedent, I think at triple or quadruple even the pace of the Roberts Court. I do think the Chief Justice values stare decisis, values precedent. And so I think what the justices do genuinely try to avoid overruling precedent where they can. That's why I think with Humphrey's executor, they're more likely to limit that case, not just to the facts of the FTC, but as John was saying, to the facts of the FTC as it was understood incorrectly in the 1930s, effectively giving it no reach. But that spares them, I think, what they see as the public relations problem of using that O word. So if, with all due respect, if our friends on the lower courts expect the Supreme Court to overrule more cases, I think you might be disappointed.
Yeah, look, I think there's no question that the court respects stare decisis. There's no question that the Chief Justice would like to move slowly and is very, and is concerned about the view of the court in the public sphere and the political sphere and the like. I mean, I think there's a lot of examples that could attest to that. But again, I think this court hasn't been afraid in the big cases, most notably Dobbs, which of course the chief wasn't fully on board with, but also in Loper Bright and the like, and in some of in these areas in which I think the justices, a majority of the justices, feel that the precedent is wrong, they've clarified the law. But again, I mean, as for lower courts, that puts lower courts in a difficult position, and the lower courts, most of these removal cases are now working their way through lower courts, and so there are credible arguments that even if you accept Humphrey's executor as it was written, if you take into consideration Seal of Law and Collins and others, like that that you don't need to overrule Humphrey's executor to say that the president can remove these powerful executive actors on the NLRB or on the FTC or the like. And so lower courts have to accept the precedents for as long as they are the precedents. But I think there are bases for siding with the government on these issues as of today. Whether the court, when it gets these, tries to clarify the law. I guess this unlike some things, is something that probably can be proven true or false in a couple of years, if not next term.
Yeah, and I'll just say I don't think it's only the lower courts that would benefit from more clarity in this area. It's also litigants and lawyers. As someone who's litigated the scope of the Humphrey's executor exception, and I think the lower court got it wrong in our particular case, but did so because it could at least kick up enough dust about what Humphrey's executor meant and what it didn't mean. I from a selfish standpoint, would love to see the court just overrule Humphrey's executor and provide that clarity, not just to the lower courts, but to litigants and parties that may be challenging executive action.
Steve, you mentioned a durable conservative majority. If you had to describe the court, would you say it's a 6-3 court or a 3-3-3 court or something else?
Yeah, I mean, it's always risky to kind of categorize. I mean, I think it's a durable conservative majority in the sense that there are 6 justices who are taking positions that are kind of consistent with where the right of the court has been, you know, in recent decades and the like. But each justice is approaching, you know, these cases, you know, one at a time based on their own judicial philosophies. And so, you know, there are some ways in which, you know, we see 3 of the conservative justices taking a different view, and there are some ways in which Chief Justice Roberts has his own views on these questions, and there are some ways you could talk about some of the other justices, you know, being on the right, but talk to, you know, Justice Gorsuch about Bostock, and, you know, he's got strong views on that question, and those questions don't align with some of the other justices, you know, on the conservative side of things. So I think I wouldn't want to be overly simplistic, but I think it is fair and meaningful to say that this is not a court afraid to kind of come down and, you know, on the right side of jurisprudence, you know, the conservative side of jurisprudence in some of the big cases, and that more often than not, there are 6 justices going that way.
I can agree with that to a point. I mean, I would probably describe the court more like 3-2-1-3. You know, if we're talking about the most, you know, high salient constitutional cases. Of course, if we're talking about
Is the chief the one?
No, I'd say Justice Barrett is probably the one. I see, you know, the Chief Justice and Justice Kavanaugh voting with each other 97, 98% of the time every term. And I think that their philosophies are somewhat similar to each other. I think perhaps Justice Kavanaugh being more conservative. But I think Justice Barrett is increasingly staking out her own approach, which is, I would characterize it as very cautious, very incrementalist, and very formalist. And I think we saw that especially last term in a bunch of the presidential power cases where she did kind of go off on her own and reject the leadership of the Chief Justice in those areas. Justice Gorsuch, of course, you know, grouping him with Justice Alito and Justice Thomas, I think that you know, in the most high salient constitutional cases will often work. But I think it's fair to say that, you know, Justice Gorsuch has some more libertarian leaning instincts. And in some types of cases, whether it be criminal or immigration cases, he can actually be most aligned with the 3 liberal justices. And so, you know, I agree with Steve to a point that it is a conservative majority, but I think there's great diversity, intellectual diversity within that majority. And I'll just point out that, you know, conservatives have lost some very important cases at the Supreme Court in the last few terms. You know, as an election lawyer, the first that comes to mind is Allen v. Milligan, a case under Section 2 of the Voting Rights Act. And, you know, as election lawyers know, that is a case which effectively allows one political party, the Democrats, to gerrymander while the Republicans cannot. And that has resulted in a substantial number of congressional seats flipping from Republican to Democratic control as a result of that decision. And so, you know, you can still lose cases. It's not so durable of a conservative majority that conservatives won't take major losses, at least sometimes.
See, this may be a function of age, because I spent 25 years losing a lot of big cases.
Nice to get some wins. It was a while.
We've been doing better over the last 5 years.
I think whether it's 3-3-3 or 3-2-1-3 or 4-2-3, I think we can all agree that there are 3 on the left that are pretty monolithic. And then on the conservative side of the court, there is some variation. And I think it really turns on the questions presented to the court and the subject matter. Some of the justices on the conservative side in civil rights cases, where I do a lot of my practice, have a particular view. And even Justice Thomas will sometimes vote with the liberal bloc on certain questions related to Section 2 of the Voting Rights Act, or the Constitution's protections to the right to vote, just because of how he views, for example, he doesn't think Section 2 applies to redistricting. And so sometimes his voting patterns in those cases are not in line with other quote unquote conservative justices. So there's just variation, I think, as Lou points out, in the various approaches among the right. I don't see that much variation on the left.
Few cases, though, where Justice Jackson separated from Justice Sotomayor and Kagan.
Exactly.
I read the opinions, but I didn't have any insight as to why, or it might be too early to tell. Do any of you have a take on Justice Jackson's philosophy that would indicate the same sorts of areas of disagreement that we see with Justice Gorsuch peeling off in cases perhaps involving Native American rights, rule of lenity, things like that?
The most high-profile case where Justice Jackson peeled off was the Fisher case, which was about the prosecutions of January 6 defendants under a statute designed to deal with, obstruction of justice, and they repurposed it to try to prosecute the January 6 defendants. Interestingly, Justice Barrett was on the liberal side here with Justices Kagan and Sotomayor, and Justice Jackson joined the Chief Justice's opinion. What explains that? I think Justice Jackson, she was a public defender. I think she's going to be particularly solicitous towards the constitutional rights of criminal defendants. I think Justice Kagan, and to a lesser extent Justice Sotomayor, are more pro-government than Justice Jackson. And so in some of these sort of libertarian versus government lineups, you might see Justice Jackson on the more anti-government side.
Yeah, and all this is say that these are 9 individuals who are kind of working out these issues on one case at a time, and so I think it's useful and kind of meaningful to sort of talk about trends and talk about areas in which they are likely to agree, but in each one of these cases, they're voting separately. They're not block voting.
Let me invite our audience to go to the microphones if you have questions. And while you're doing that, another important case was decided in 1935. It wasn't just Humphrey's executor, it was Schechter Poultry. Yeah. We haven't said anything about non-delegation, perhaps not necessarily germane to this panel, but I'm curious, anybody expect that to be a fertile ground of litigation? Will we be seeing cases in that area?
Well, the court has a case that's pending right now, coming out of the FCC, although at least based on oral argument, it sounds like it may not break major new ground on non-delegation. Non-delegation makes perfect sense as a doctrine, protecting Article I power and Congress's ability to make the laws. I think the difficulty is coming up with a judicially administrative standard that sort of separates one, statute delegating authority of the executive branch from another, and I think if there is a great answer to that, I haven't heard it yet, but it's definitely another way in which the court is trying to save Congress from itself, in terms of preserving congressional authority and narrowing delegations to the executive.
All right, we only have 13 minutes, so I want to quickly go to the questions and make sure they're quick because I want to try to give all 5 of you a chance. Please identify yourself and ask your question.
Stuart Weiner, and the question is quick, the answer may not be. I'd like to ask the panelists if you could touch upon executive power in the context of executive orders about the civil rights law and also immigration.
Executive orders are formally, they do one of 2 things. They're either directions to the executive branch, in which the president tells his officers what priorities or what actions they should be taking, or they trigger statutory delegations, in which the president, for example, under the immigration code, can make proclamations to restrict entry of categories of aliens into the United States, as President Trump did with the travel ban and the like. And so, on the immigration context, they're often legally operative. Many of the other contexts in which we've been seeing them by President Trump, who is an aggressive user of executive orders, is a way of having the White House set the policies of his administration. He's not waiting until his cabinet secretaries, set their own policy, across on a variety of issues, but he's telling folks what to do. And consistent with what we've said about Article II, that's within the bailiwick of presidential power.
Yes, sir.
Paul Johnson from the New Jersey chapter. Question on unitary executive theory or fact. I think it's fact. We all agree institutionally it would be a bad idea to fire the Federal Reserve Chairman, or a sequence of chairmen. It would be a bad idea. Constitutionally, I think the president has, the authority to do so. Isn't the way to protect the sensitive jobs the threat of impeachment?
I'm sorry, I didn't hear
The threat of impeachment.
The threat of impeachment. Oh,
Right. I mean, if the president's going to do really outrageous things like that, wouldn't the threat of impeachment prevent him from doing so?
I think that, and I think the threat of electoral or political pushback or blowback from the American people. The unitary executive structure of our government recognizes that the president is the only official elected by the entire nation. And because of that, he's now democratically accountable since we have popular election of electors to the Electoral College.
I had a question about Justice Jackson's concurrence in the Steele Caesar cases in terms of whether you can parse out some of these delegations as whether they're more close to a traditionally executive power, like foreign policy in the case of tariffs. And so you might say, well, Congress gives the tool, but then the court should give a lot of leeway in terms of how to use it, or blocking or deporting certain kinds of aliens. Might contrast that from control over the money supply. Also question whether that is constitutional at all for the government to have that kind of a private bank. So I just had a question whether that would be the guide of choosing whether it's quasi this or quasi that, whether it's relevant at all.
So there are two major areas where the executive is acting where I think you could make that argument, and that would be tariffs and really all foreign policy adjacent actions and immigration. Proponents of the non-delegation doctrine, including Justice Gorsuch in his Gundy dissent, acknowledge that delegations can be much broader in areas where the president has inherent executive authority. I don't think that argument is foolproof, especially because the Constitution expressly delegates power over both tariffs and immigration to Congress, but there's certainly some precedential support to suggest that perhaps the executive branch also has inherent authority there. That being said, I was talking about the blank check delegations. Most of them are not arguably in areas where the president has inherent authority. So under the Youngstown Jackson approach, for example, federal workplace safety, where the president basically can do whatever he wants, that's not an area of inherent authority. But yes, absolutely. That's an important line in these cases.
Hi. It seems like the problem with trying to create a non-political bureaucracy is that it runs into the take care clause. But Congress could solve that by moving the bureaucracy to itself. So I guess my question is a two-parter. If you see a stronger executive unitary theory, do you expect Congress to move the bureaucracy under itself? And what would be the limits to that, other than potentially non-delegation?
If I understand the question, you're saying Congress could basically have the civil service working for Congress, if that's?
Well, it wouldn't run into a take care problem at least.
Yeah, no, I think obviously that is an issue, and there's a line of cases on legislative aggrandizement, in which the court has kind of narrowed the ability of Congress to sort of share in executing the laws, and so Congress could certainly increase its staff from the standpoint of increasing the its ability to kind of make fact finding and provide recommendations internally, and therefore pass legislation, but. I think, when it comes to executing the laws, the federal government has a lot of responsibilities, which is why we have such a large bureaucracy, essentially, within the executive.
Yeah, and I'm not sure how you necessarily would square that with the vesting of the executive power in the president. If these agencies are going to exercise executive power, then necessarily they have to be subject to the president, not to Congress.
One quick point on this, whenever you hear anybody defend the inevitability of the administrative state on the grounds of expertise, just remember, the experts in the agencies could walk over to Capitol Hill, share their expertise with the members of Congress, and ask Congress to vote to enact their expertise. They don't want to do that. The debate that we're having is not really about expertise, it's about power.
Sir.
Jude Joannis, could the panelists assess the president's effort to reclassify federal employees as policy career officials as well as like the practical effects of that, and how you think the federal courts will react to any lawsuits that work their way up.
Sure. And this is something that President Trump started in his first administration, what they call Schedule F. And so the civil service laws are fairly complicated, but a lot of the schedules, a lot of the classifications, including the for-cause protections that civil service employees have, are based upon executive orders ultimately. And so the president does have the authority under statute to identify categories of persons with policymaking authority and to basically put them in a separate schedule that removes their for-cause protections. And so President Trump started that at the end of his last administration, and not surprisingly, on day one, he's continued to carry that out. I think that will have some impact, but it depends on who is scheduled that way, and it doesn't necessarily reach as far. I think there's also the separate category that Lou mentioned. I think it was Lou or maybe John about the SES, and there were also issues there, and those have statutory protection that are sort of separate from Schedule F, even while the SES folks are quite important in the authority that they do.
Thank you.
All right. One more. Okay, go ahead.
I can sneak up. I wonder if the panel would comment on the Alien Enemies Act, particularly given the age of that statute and how that fits in with some of the issues that you've been addressing.
I mean, the history here is complicated. I think the statute fits uncomfortably with modern due process protections. And to be fair, there are Supreme Court precedents suggesting that illegal immigrants have substantial procedural due process rights. I think that if we were to try to come up with a sort of first principles and perhaps more workable approach, right? Because the fundamental problem is, if you have to have individualized trial-like proceedings for every illegal immigrant, you're never going to make serious progress in deporting people. President Biden allowed about 10 million illegal immigrants to come into the country. I think I saw one study suggesting it would take like 500 years to remove them all if you had to give a full adjudicative proceeding to all of them. I do think, as a sort of first principles matter, the 14th Amendment, the Due Process Clause, does apply to a category beyond just citizens, right? It refers to persons. And I think at the bare minimum, the government would have to offer a hearing where someone could contest whether they are a citizen or not. And indeed, we don't want the government deporting citizens, so that might not be such a bad idea anyway. But I do think that we need to arrive at a workable yet principled approach for this area.
All right, it looks like lunch is being set up out there. Please join me in thanking our panel.